That brings us to item number 8, AB 2827. Mr. Levine.
Good morning, Mr. Chair and members. I am pleased to present AB 2827. This bill allows companies a 33-day right to cure for alleged de minimis violations of California's Made in USA and Made in California labeling laws. This right to cure is very similar to other provisions of California law. While the various rights to cure are not all identical, they all exist to bring about compliance with the law and to avoid egregious, vexatious, and costly legal actions. This is needed because earlier this year, California small businesses began receiving demand letters from a particular consumer attorney in Los Angeles. The demand letter requires these companies to do all of the following within 30 days of receiving the letter. 1, cease and desist selling all of their products. 2, conduct an advertising campaign to inform consumers of the alleged mislabeling. And 3, initiate a full recall of all products and offer full refunds. Compliance with such demands would put these companies out of business. Remember, these demands are for the entire product line sold in all retail outlets and online. The letters threaten legal action if the demands are not met. The plaintiff's lawyer concludes in the letters, if the company wishes to enter into discussions to resolve the demands asserted in the letter, please contact me immediately. As you can imagine, these companies feel that they are being subjected to a shakedown. I have a great deal of respect for consumer attorneys and believe that they serve the public interest. However, in this situation, the attorney is pursuing what California companies commonly refer to as jackpot justice. These small businesses believe that they are in full compliance with the law. They believe they have done nothing wrong. They believe that they have never received any complaints about their products, and these demands are unsubstantiated and are coming out of the blue. They know that if they pay a settlement, if they pay that shakedown, the whole thing will go away. So they have to weigh the cost of fighting vexatious litigation in court with the cost of paying out a settlement. I appreciate the comments on page 6 and 7 of the analysis highlighting the various remedies available to deal with vexatious litigants and unethical attorneys. Please keep in mind that these remedies highlighted are costly and lengthy legal proceedings. Comparatively, this bill seeks to address this problem at the front end, not after the fact. Additionally, these small businesses are not in the litigation business. They are small businesses and simply don't have the time or the financial resources to pursue such legal actions. Additionally, let us also remember that in the ADA situation we experienced only a few years ago, it took the Sacramento Bee investigative report to shine a light on the unethical attorneys who are causing harm to thousands of California business owners. Do we really want to ask small businesses to go through that experience again? Instead, I believe we can learn from that history and act to prevent it from happening. This issue came to my attention through a widely respected small business in my district that received a demand letter. The company is located in an underserved community and has a reputation of being active in the community, philanthropically and civically engaged. I quickly learned that there are hundreds of other cases just like this. My staff has provided your offices with a small sample of the demand letters that are being sent. This sample is for a small company in San Francisco that sells men's grooming products. When these small businesses attempted to learn the origin of the demand letters, they found that the plaintiff's attorney utilizes a website called gotaclassaction.com. The website is searchable and includes a tag for Made in USA cases. Yeah, gotaclassaction.com. It identifies Rockstar Energy Drinks and the Heinz Company as two examples for alleged Made in USA violations. Both actions were filed, get this, on December 31st by the same lawyer, and both actions are for the exact same plaintiff. I withdraw my second. There is no doubt that all of these cases exist only because plaintiffs are being sought online at gotaclassaction.com. They're not paying me to say that. Rockstar and Heinz are large companies, are better situated to defend themselves. However, small businesses...
But somebody's paying you by the word.
Yeah. Like the company in my district or the company in San Francisco cannot afford costly litigation and have to immediately consider a settlement to make the cases go away. By establishing a right to cure, this bill will discourage egregious and costly legal actions. Instead, this bill offers a simple solution to address alleged de minimis violations. With me is Angela Deach. It's close, guys. With the law firm of Gilbert Kelly and Jennifer Barrera from the California Chamber of Commerce, as well as Chris McKaylee, Ms. Deach has represented several companies who have received demand letters or been subject to complaints.
We finally got to the end on that.
I'm sorry, Mr. Alejo, what was that?
I said we finally got to the end of that.
Oh, okay. So we have a motion. Mr. Alejo withdrew his second.
I'll second it.
All right. First witness, please.
Yes, hello. My name is Angela Deach. I'm with the law firm of Gilbert Kelly, Crowley, and Jennett LLP out of Los Angeles. My office is here in Roseville. I represent a number of cosmetic companies, personal care companies, that range in size from very small. They have, say, one product in the market and they're trying to grow, to companies that have hundreds of products. I know of at least 20 companies that have received demand letters, 20 cosmetic companies specifically, just based on the companies that I represent, as well as a few attorneys that I know throughout the state that are also representing other companies. The claims are that they're making, the demands that they're making are egregious. They would bankrupt just about any company trying to comply with the demands. Now, my clients happen to be more of the, I wouldn't say conventional cosmetic companies, the more of the kind of natural, organic companies. You know, they strive to use natural ingredients. They strive to use organic ingredients when available. You know, these are companies that work really, really hard to create products that are safe for consumers, and they work really hard to make sure that they're complying with the laws. They manufacture, many of them manufacture right here in California. But unfortunately for cosmetic companies specifically, not all ingredients are available in the U.S., which the legislature with SB 633 did acknowledge that there's just some ingredients that are not available, so there are opportunities that you can purchase or obtain ingredients from elsewhere. But what I'm trying to say is just that, you know, these companies work extremely hard to comply with all laws here in California. And they feel like right now that they are being put, you know, a gun to their heads. We've tried to negotiate with the plaintiffs' attorneys and tell them, no, look, these ingredients are all from the U.S. We manufacture here. The bottles are from here. The labels are from here. And they don't care. Because they just figure, well, if we can just continue to put pressure on you, eventually you'll just agree to settle. It's pretty much extortion. So we ask that there be this right to cure period. And the reason for that is even though it may not stop all of the lawsuits, it at least gives the plaintiff's bar a moment to decide, well, should we really be pursuing this? Should we continue? Because at this moment, there is no reason for them not to go forward. A plaintiff is not actually paying them. It's all on contingency. So if they could at least get some money, whether it's $30,000, $50,000, $100,000, because the companies that they're going after, at least the personal care companies that they're going after, they're large enough to pay a settlement. They're not large enough to pay extensive defense fees. It's just not the case for them. So I respectfully request your support. Thank you.
Thank you. Next witness, please.
Mr. Chair and committee members, Jennifer Barrera on behalf of the California Chamber of Commerce, and we are in support of this bill. I'm just going to address several different points and try to be efficient with my comments. One of the issues that have been raised is that this would be an unprecedented area to create a right to cure, which I disagree with. We have a right to cure under the Private Attorney General Act for the Labor Code, which is similarly 33 days. And there is not an agency that verifies whether or not the claims have been cured. There's a notice provision to the labor agency, but the labor agency does not have to investigate, and they don't have any follow-up with regard to determining whether or not the employer has actually cured the violation. So it's very similar to the proposal here. There's also a right to cure with the Gender Tax Repeal Act with regards to services for women versus men, and if there's a different charge made on a business who has a pricing issue with regards to whether or not they've identified the pricing of those services, has 30 days to cure before a penalty is issued. Again, there's no agency that determines whether or not the business has in fact cured. And then again, with the ADA issues going on with a small group of attorneys similar to this situation who were tainting the issue, there was in SB 269, what this committee just passed recently, there is a 120-day right to cure as well. Again, no agency is verifying whether or not the issue has been cured. It does go to a court if there's litigation going on, but there's no agency. So I would say that this is similar to other areas of law where there has been a right to cure. I agree with the comments made that this is trying to address the issue at the front end rather than the back end. Under the Consumer Legal Remedies Act, even if a defendant goes through the entire litigation and proves that the claim was false, that they were in compliance with the law, they're not entitled to their attorney's fees unless they go one step further and show that the litigation was filed in bad faith. That's a huge step for them to prove. It's a high evidentiary burden to satisfy, and it's another legal proceeding that they have to achieve in order to get their money back to show that they actually were in compliance with the law. What this provides at the front end is the opportunity for them to avoid class action altogether by just simply removing the Made in the USA, Made in the County, wherever they have identified from the label before even pursuing down the class action, so they can avoid those costs altogether. And with those reasons, we are in support of the proposal. Thank you.
Thank you. Next witness, please.
Mr. Chair, members, Chris McKaylee on behalf of the Civil Justice Association of California. Just two quick points. One is why wait? Let's get out in front of this. It took years of instances of abuse in ADA, Section 17200, et cetera. Let's try to do something proactive early. The second point is that some of the alternatives that the opposition has pointed to, including vexatious litigant, requires a mini bench trial. You heard on your bill, Mr. Chairman, about the concerns with the state bar discipline. All those types of alternatives are time-consuming and costly. Thank you.
Thank you. Others in support, if you could just give your name and affiliation. We're not going to take further testimony.
Joe Devine on behalf of the Personal Care. Joe Devine on behalf of the Personal Care Products Council and strong support.
Thank you.
Anthony Molina on behalf of the California Manufacturers and Technology Association in support.
Angie Minetti with the California Retailers Association, also in support.
Thank you. Anyone else in support? Seeing none, opposition.
Good morning, Mr. Chairman and members of the committee. Richard Holliber with the Consumer Federation of California. This committee and the legislature has looked at several bills dealing with California's Made in USA label law over the course of the past few years, and last year enacted Senate Bill 633, which took effect at the beginning of this year. And within a matter of weeks, you are being asked to consider changing a law that is brand new before there's been any opportunity to see whether or not this new law addresses these alleged problems with so-called de minimis violations. Now, California has always allowed for what is called a qualified Made in USA label. So you see these in stores, assembled in USA with domestic and imported products is perfectly legal if truthful. 90% components made in USA is perfectly legal if truthful. What we're talking about here is an unqualified claim that simply says made in USA. And we know that there's a huge marketplace advantage because polling referenced in the analysis shows that 64% of American consumers are willing to pay more money for something that is truly made in the USA. And there are many reasons for it, including supporting American labor, supporting our higher environmental standards, patriotism, higher quality of domestic products, and so forth. So this is a label that is worth a great deal of money to manufacturers. Last year, the legislature said, okay, what about these examples where a screw, a washer, some modest, tiny piece of a product is imported, perhaps because it's not available in the U.S., and change the law to allow as much as 5% of the content to be non-U.S., regardless of the reason, no reason given, 10% if the manufacturer asserts that the content cannot be obtained from a domestic source. So we think that this has addressed the kind of modest, de minimis kinds of claims. We don't have yet any opportunity to see whether or not it has solved what some folks would say were some legitimate problems with the law. And let's give it some opportunity to see whether or not it works before there is a change in the law. I mean, the fact is many manufacturers go the extra mile because they want to support American production.
So I need you to conclude.
To have products that are made in the U.S. This would allow those who don't go the extra mile to see how far they can go, how long they can get away with a violation before they're caught with no penalty. Thank you.
Mr. Chairman and members, Barry Broad on behalf of the Teamsters, the machinists, longshoremen. This right to cure thing is very popular, but it seems to be sort of a one-way street. I suspect that the proponents wouldn't feel so sanguine about a right to cure if it was about trademark infringement or copyright infringement or some other business-to-business litigation that occurs. Nor would we feel so sanguine about Volkswagen. Maybe they should have a right to cure. At some point, the law is the law. And I don't even know what a right to cure, the demand letter that's referenced here, I don't know what the right to cure false advertising is if you get to leave the product out in the market falsely advertising. So I don't know what they expect to happen here, but it sounds like if you get caught, nothing happens. And frankly, we've seen this issue come up over and over again. There seems to be a strong desire by companies to say made in the USA when things aren't made in the USA. And it's a simple consumer issue. People are entitled to have the truth. And when you don't tell the truth, there needs to be consequences. And this is basically eliminating the potential consequence. It's taken away the hammer. So we would urge a no vote. Thank you.
Thank you. Next witness, please.
Good morning, Chair and members. My name is Elise Sanguinetti. I am the president of the Consumer Attorneys of California. Labeling is a very important issue right now, and if this bill passes, then surely other companies that mislabel their products organic, approved, natural, cage-free will ask for the same protection. It's a slippery slope that should not be embarked upon. Consumers usually pay, as stated earlier, a higher price for products labeled made in the USA, organic, cage-free, etc. And the law is meant to ensure that the purchaser is getting what he or she paid for. We also think that the bill is bad precedent. If the legislature has issues with the law, then it should be reviewed for amendments. But it is contrary to sound legislative policy to give businesses and employers a free pass for violating the important labeling, consumer, worker, and environmental laws that California legislators work hard to pass. For these reasons, we respectfully ask for your no vote.
Thank you. Anyone else in opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Mr. Gallagher?
Yeah, I just want to say I love this bill. And, I love it so much I think we need to replicate it and do it in a lot of other circumstances as well, because I think there are a lot of now it doesn't work for every single situation, and I respect the comments that were made there that you don't want to give someone a free pass on everything, but certainly on some things, and certainly in this situation, I think having a right to cure makes a lot of sense, and I think especially when it relates to the regulatory world, where for very de minimis minor violations of a regulation or a statute, businesses in my district, small businesses, end up getting $8,000, $10,000 fines when it's something that they could easily have just cured, come into compliance, the spirit of the law is met, and instead they're punished. And in these cases, this has really honestly just created a bar for attorneys who go out there and sue in the hopes of recovering the penalties and the attorney's fees associated with the whole thing involved. It's really not about necessarily protecting the consumer. To me, it's something. It's yet another thing that is abused, and the real winners end up not being the consumer, but the attorneys who bring the suits. I'm going to support this bill, but I would encourage that we should do this in a lot of other circumstances as well. Obviously, we had that discussion about ADA last year. We decided not to move in that direction, but I think in a lot of other functions in the regulatory world, it makes a lot of sense to allow businesses to have a right to cure.
Other questions, comments? Mr. Chu?
So first of all, I want to thank the author for, I think, pointing at what is a real problem. I think we all understand that the vexatious litigant that we're talking about is someone who is engaged in behavior that I don't think any of us are particularly excited about or want to condone. That being said, as I've discussed with the author, I have had challenges thinking about what I am concerned of as the perverse incentive of what happens when, if we were to move forward with this right to cure, we would create the incentive for certain businesses to simply create made in the USA products and do it until they get caught, and then they would have 33 days to fix the problem. And so I am not prepared to support the bill today, but I do hope that there's something else that we might be able to do in this context.
Thank you. Any other comments? Mr. Lamine, I am recommending a no vote on this. This is a brand new law, and I think one attorney may be doing something that's outside of certain bounds, may be an issue, and then the notion of vexatious litigants comes up from time to time. In the ADA, that was a long, drawn-out process to really identify what the problem is, incentivize the right behavior, and compromises were drawn. I think that if we're going to be looking at this particular situation, since it is so brand new, we need a little bit more time to understand what the patterns really are and where the issues arise, and then see if there's something that we need to take a step on. I know that there are certain products out there or certain manufacturers out there who are being challenged by this, and a demand can be made of anyone at any time. That doesn't necessarily mean it's going to hold any water. It does not necessarily mean that there's a path there. And for this attorney, if enough companies push back, this attorney's not going to make any money off of it, and we'll find something else to do. This is the way the system is set up. We do have a lot of other places where we have regulatory oversight, and it is a governmental agency, it is a bureaucracy that then comes in and enforces. Absent that, our system is set up this way, for better or for worse, to have private individuals enforcing our laws, and for a company to then make a business decision about whether or not they're going to follow California law because they have an out at some point, I think works against our ability to have a rational and meaningful system. So again, under certain areas, there have been right to cures that have been put into place, but that's after a long substantiation of what the problem is, and after other attempts to try and rein in those attorneys, because even in the ADA arena, there have been laws that have been put on the books that have reined it into some extent. Then somebody figures out how to go beyond that. That's why it's been an ongoing conversation. I just don't think we're quite in that situation here. That's why my no recommendation. All right. So with that, you may close.
Yeah, thank you. Really appreciate the commentary and the dialogue today. The opposition's arguments were really insightful. We heard Mr. Holliber talk about the law just going into effect on January 1st. The demand letters went out December 31st. No one is waiting to see how this law plays out. They're going after shaking down these companies. No one else is waiting. They're ready to sue. And to the point that Mr. Broadhead made about false claims, one lawsuit against a San Diego company, Stearns, says that they're making a claim about being made in the USA. They've never made that claim, and they're being sued on it. And so we as a legislature have gone to incentivize people to manufacture here in California, and what we've actually done is set them up to be shaken down. And I think that Mr. Chu is right. We have identified a real problem. So what I'd ask of the committee, with your blessing, is let's hold the bill today. Let's work on this problem through the week. Let's try to work with the committee and try to figure out a way to protect these companies from these lawsuits and give this time, much like Mr. Stone had asked for his bill to actually be released from this committee to continue working on an issue. I don't need it to be released today. Let's continue working on it here. Let the committee work on it together, and maybe next week we'll have something that does solve the problem and protects California businesses. Thank you, committee.
All right.
Mr. Chair, I will withdraw the motion if that's...
Thank you, Mr. Wagner.
And it's a realistic opportunity for this committee to continue working and maybe reaching consensus on this bill.
Yes, and I would like to ask for this bill to be agendized for next week.
Okay, I don't think there's enough time to solve the problem.
Okay, so should we release this bill from this committee just like you asked for your own bill earlier today?
There's a motion.
The motion was withdrawn.
Are you withdrawing your motion,
Well,
Mr. Wagner?
I will withdraw the motion and urge the committee, as Mr. Levine has invited, and maybe next week is too soon, but there are issues here that could be worked on, I think, and worked on profitably. I'll leave it to the author. I will withdraw the motion, or I will leave it for a vote, as is the author's will, but I mean, I think the question is for the chairman at this point, is there an opportunity to make some progress on this issue?
My concern is that we open up the legislature to ridicule, that we have identified a problem, and yet we won't allow legislators to continue working on the problem. Give us one more week, and perhaps we'll have a resolution. If we don't, then we don't have a bill. But there's nothing wrong with having the legislature continue working on the problem. After all, we're lawmakers, and that's our job.
Okay, the only reason that I will hold it, but not promise to agendize it next week if we don't have a solution.
Well, let's agendize it, because then we actually have a way to bring stakeholders to the table and negotiate a compromise that protects California businesses but also protects California consumers.
Mr. Lee, you've had your hearing.
Yeah, I have.
And it would be for vote only next week if we can reach an agreement. If we can't reach an agreement on it, then I will not set it for next week.
Well, let's figure it out.
Okay, under those terms then, without objection, we'll hold the bill.
Great. Thank you, guys.
Thank you. Mr. Thurmond.